Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in lovely Peckville, Pennsylvania, and I am right here with you each and every week at this time on this station to bring you, the landowner, the information you need regarding natural gas development here in Pennsylvania. And of course, and as always, I, Doug Clark, the Clark Law Firm, has not, will not, do not, none of the above, have not, do not, and will not represent gas or pipeline companies. I represent landowners, gas right owners for such items as oil and gas lease negotiations, reviews, consultations, pipeline, water line agreements, well pad agreements, unitization issues, royalty issues, deduction issues, surface use agreements, you name it, estate planning related to oil and gas matters. Also, any type of easement agreement, compressor stations, you name it, again, any and all issues related to natural gas, buying, selling gas rights, real estate involving gas rights. Give us a call. You hear me talk, I'll touch on reviews and consultations some today. You hear me talk about it all the time. It's just been a wonderful thing where I do a review and consultation. You get an offer, you get documents, you get something sent to you from a gas or pipeline company. You put down the pen, you pick up the phone, you give me a call. You call the office here, 570-307-0702, regardless of your location, as long as the oil and gas rights and property is in Pennsylvania. Regardless of location, I really encourage you, give me a call. Start with a review and consultation. Great way to start. Usually takes 2 hours or less. You send me in the information. I review it. They're all done by me personally. You can come to the office. We'll do the review and consultation in the office. I go over the documents. I answer all your questions. I tell you every single thing that I think you need to know. Explain your leverage, your options, and your rights. Or we can do that by telephone. I have a client right now in the state of Oregon, Texas, California. So I have clients all over the country, and it works really well. We do these by phone. We get on the phone, do a conference call. So whether you're in Western Pennsylvania or any place in the country, North Central Pennsylvania, give us a call. Find out if it'll work for you. Start with the review and consultation. If that works for you and you need additional representation, great. If you do the review and consultation, you often hear me say the worst thing that can happen is you spend a couple hours of time and money, but you got your questions answered. You understand what you have. You have somebody working for you, explaining the documents to you and giving the information you need to know to make the right decision. So really encourage you, give us a call, any oil and gas related matter, but reviews, consultations, again, it's a great way to start regardless of your location. I have clients in all gas producing areas. I've represented clients in all, to my knowledge, of gas producing areas. So really encourage you, get some information. Remember, the landman works for the company, not you, the landowner. And remember this, I, Doug Clark, work for the landowner, not the company. Never have, never will. So, okay, why do I say these things? Why do I say the landman works for the company, not you, the landowner? Why do I say it? Well, because we need everyone to understand, because still people hear the landman talking to them and they say, well, I have a human being in front of me saying words that I'm hearing in my ears. And as a general rule, I am a reasonable person. And as a reasonable person, when somebody speaks words and I hear them into my ears and I process them in my brain, a reasonable person tends to believe what they're being told. It's just reasonable. You tend to believe what you're being told. Doesn't mean what you're being told is the truth. Nonetheless, we all know that we have a tendency to believe what we're being told is true. We don't come in as a general rule thinking whoever's talking to us is lying to us, because we don't operate that way in our daily lives. We don't go out and just lie to people in order to get people to do something that we want them to do. We just don't generally do that. Good people, well, let me strike that. People don't generally do that in their daily lives. However, imagine this. Let's use a salesman who is trying to sell you an automobile. And let's say we'll do the classic used car thing. So that salesman may say, hey, this car was owned by an older lady who always drove 45, never went over the speed limit, 55 maximum, and just drove to and from town and really took it easy, never been in the car wreck, any of these things. It was just an unbelievable opportunity. She asked to get rid of it. So you say, well, geez, okay, that sounds good. I'm going to probably believe that, but a used car dealer, maybe I got to, check. Nowadays, you can go on the internet and look at different things with car problems, whatever. But the point is that this gentleman is telling you this information, and you're either going to say, okay, hey, I'm going to believe this information, or I'm going to highly doubt it. Now, in a used car situation, because of this, just reputation, some people may think that this information is suspect, but then a lot of people are going to say, hey, that sounds, okay, that sounds great. This sounds like a really good deal for me. Why would this guy lie? Well, it's similar, when we talk about the landmen, and I don't want to say that they're used car dealers. I'm not saying that. What I'm trying to say is when somebody is communicating with you, you need to, on your side, assess the motivation on the other side. For example, if you stopped along the road, now this is, I'm just having fun with some examples here, but just as an example. So if you stop along the road and you say, hey, sir, I'd like directions to Mr. Smith's house. I know I'm in the area, but I'm lost. So the gentleman who you asked for directions says, okay, you go up 2 lights, you turn right, you go down a light, you make a left, and it's right on your left-hand side. So you say, well, okay, again, I'm going to believe this guy because why would he lie? And people don't generally lie. Now, scenario 2, same deal. You stop, you ask this guy. Guy says, boy, you're way off. You got to turn around, go back a couple blocks, make a left, make a right, go down, make a right, another left, another mile or 2, and it's on your right-hand side. Well, these are obviously totally different directions. Well, again, these are just examples for fun, but maybe the person you asked for directions had a motivation other than to just give you the direct information truthfully. Maybe it is that this gentleman on the street that you asked for directions is an arch enemy of Mr. Smith. That they have a long history, and he says, I really dislike this guy. I can't stand Mr. Smith. So therefore, I am not going to help out and give him directions. I'm going to lie and send this guy on a goose chase. So, again, bizarre, just the story. But the point is that you need to understand when you're dealing with matters of consequence, such as signing a gas lease, signing a pipeline agreement, any and all oil and gas related contracts. You need to understand the motivation in the mind of the person you are communicating with. So, if you're communicating with a person who is working for the company, who is tasked, given the job, to get you to sign a document, and to get you to sign the document for the lowest possible compensation or amount of money, to get you to sign a document for the lowest amount of money and with the most broad terms, meaning let's not let the landowner restrict this agreement, and let's pay them as little as possible. That is that person's job. That is their job. So in their mind, when they knock on your door, their job is to secure your signature for the lowest possible price and to provide you the least available addendum or additional terms to make the agreement better for you. Ladies and gentlemen, you have to understand that. And it's okay. That's their job. It's okay. They have a job. Respect the fact that they're doing it. But we have to understand their job. And one step deeper, we have to understand their motivation. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus. So, we have to understand what's in their mind. And what's in their mind is they have a job to do. So, and I'm not saying anything specific. I'm talking very broad in general. But if you have a job to do and your job is contingent upon you doing your job well and you need to get signatures, are you going to go out to a landowner and point out all of the loopholes, all of the potential areas where maybe the agreement doesn't say what you think it says? Are you going to say, hey, look, there's probably a lot more money that you can negotiate for here because the company's really in a pickle, they have no rights here? Are they going to say those type of things? Are they going to say, listen, you can restrict this to one line, one pipeline, even though we're saying we can have unlimited or 4 lines? You can actually restrict it to one. Oh, and by the way, even though it says that we can transport frack water, polluted, contaminated water through the pipeline, if you sign this agreement, we can do that through the water pipeline, transport this frack water through there. If you ask us and you limit it to fresh water only, we'll agree to that as well. Are they going to say those things to you? I'm going to tell you, I don't think they are. Now, I'm also going to tell you, I don't blame them. That's not their job. Why is it not their job, guys? Because they do not work for you. They do not work for you. They work for the company, not you. So, if you are paying these landmen, would you want them who work for you, that you hired to do a job, do you want them going out and saying, hey, landowner, there's probably an extra 50, 100 grand that you can get here. Hey, landowner, you can limit this one line. You can limit the fresh water. You can limit the size of this easement. You can cut it in half. No, the company doesn't want that. That guy's not going to be around. Lady, guy, not going to be around very long. No, of course not. Of course not. So we need to understand that. And we're smart. We understand that. So how do we defend against this? Well, number one, we understand it. We listen to what they say, and we never pick up the pen. And if we pick up a pen, we put it down. Then we get advice and assistance from somebody working for us. Somebody whose job is not to simply get you to sign for the least amount of money, for the least amount of protections. No, you need to talk to somebody whose job it is to do nothing but help you. Do nothing but help you to read your documents, somebody who has experience in doing this, to explain to you what the rights are, to explain to you what you may be able to limit this to explain to you why you might be able to double, triple, 5 times the money you're offered, to explain to you maybe why you can't. But I'll tell you, the vast, vast, vast majority of my clients, pipeline agreements, roadway, waterline agreements, the vast majority sign for more money than what was originally offered, vast majority, and many times significantly more money, many, many times. And if they just talked to the landman, that would not have occurred. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So let me go one step further. So you need somebody who's going to answer your questions, explain these documents, explain your leverage, explain how you can probably improve these documents. My own experience, you hear me say I've been consulted with, negotiated on, reviewed pipeline agreements over 70 different companies in Pennsylvania. So you get a pipeline agreement, I have a very good idea of the type of limitations, the type of language we can add, the areas which have proven problematic in the past. And generally speaking, well, in virtually every single case, the agreement gets improved. And again, you understand what it is. And many times you can get more money, sometimes significantly more money. And, which is very important to a lot of people, you also can find if you have the right to say no, You'll find out those rights. What are your rights? And formulate a strategy. Do you want to go forward? Do you not want to go forward? So I can't, again, I always preach about these reviews and consultations, but they have proven to be so valuable, so valuable. And it is an outstanding service, I'll call it, opportunity to have somebody working solely for you with the experience of doing this stuff every day, taking an hour to 2 hours to review your agreement, to discuss what the landman told you and my impressions of that, and your leverage and your rights and how you may or may not be able to improve the agreement, and to answer all your questions and concerns. And again, if you're not doing that, either with me or somebody who knows what they're doing, and again, I can only talk about I know what I do. So if you're not doing that, I don't know why. I know so a lot of times people are like, well, I don't want to call this attorney. It's going to be expensive. It's going to be money and this and this and that. This is what I'm saying. For 1 to 2 hours, like call, get the information. It typically takes 2 hours or less. But these reviews and consultations have been great. And I'll tell you, I had one this week with several relatives on the phone, and they got done. And I love at the end, I don't always get these type of compliments, but like, wow, thank God, that was so incredibly informative. Wow, that was such great money well spent. Thank you so much. We have learned so much. This was such a great experience. Those are words, those are phrases that was said after just a call this week. And many times and look, I'm just trying to make people comfortable to do the call. Thankfully, I'm very, very fortunate. We're busy, but I can always do some more. So it's not about I'm sitting here saying, oh boy, I wish my phone would ring. I'm saying, boy, I know there are people who are afraid to pick up the phone, who are intimidated by the companies, and who are overwhelmed by this. And I want you and anyone else that says, hey, look, I'm not overwhelmed. I know I need to get help. But I want you guys to call, and I want you to find out what we do, and I want you to do a review and consultation and start that way. And again, there's no commitment after that. You just do a review and consultation. If there's more work to do, we can talk about it. If not, that's okay. But we got to stop signing these documents without understanding what is in them and without understanding the loopholes. Now, I'm up against this first segment. When I get back, I'm going to tell you, again, like a great way of where the landman represented things to people, and then we do a review and consultation. Then the people have a conversation with the company again, and then all of a sudden, things change. So otherwise, I'll save the story to the next segment. But this happens all the time. It happens all the time. So stay tuned. I'll be right back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call. Any oil and gas related matter, 570-307-0702. And by the way, when I say that, I mean if you're a person. I do not, have not, and will not represent gas or pipeline companies. Never have, never, ever, ever, ever will. Give me a call, 570-307-0702, and keep listening to All Things Marcellus. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. In case you didn't know, I've been doing the radio show since 2010. Since 2010. So I talk about doing this all the time. I've been doing the show since 2010. I want to remind everyone also, go to our websites, pagasleaseattorney.com, pagasleaseattorney.com, pipelineattorney.com. Again, if you have a pipeline agreement offer in Pennsylvania and you're not going to pipelineattorney.com, I don't know why. Use it as a resource. Always remember that the radio show is not specific legal advice. We have fun on the radio show. I get to rant and give you some information, but it's not specific advice for anyone. The advice is always get specific advice. But go to the websites, pagasleaseattorney.com, pipelineattorney.com, for general information. Learn about assessment of leverage. Learn about these issues. Again, it's not specific legal advice, but use it as a resource. We want everyone to become educated and informed And then you will either sign the best possible agreement or elect to bypass an agreement because it isn't in your benefit. And what's happening now, and what I see so much now, is not just this, in the basic leasing stuff, in some ways it became like everyone just rushed to the internet to find addendums and didn't really know what they meant and what they did. But they ran and they put them in there and they said, "Oh, I did this. I got this great agreement." Well, and then you had lawyers who say, "Oh yeah, I'm doing oil and gas work," and they're copying addendums from other agreements, things like that. Well, let me tell you, the stage has changed now. This like blanket leasing across the county you don't see that anymore in Pennsylvania. It's become much more specific, and the information and the knowledge that you need has become much more specialized. You need to deal with these issues, in my opinion, every day in order to fully understand and to see the loopholes and to watch how companies exploit those loopholes. You have to know these things in order to protect yourselves. And here's a real one quick, and this is a side story, quick common example, but side note here. I just had a company say to a client of mine, "We have the right to install this electric easement. Look at this in your lease where it says we have the right. You must sign this document." Well, let me tell you that in the lease, there is the right to run electrical power under the terms of the lease. But the landowner was not and is not obligated in any fashion in the world to sign the requested document. None. So the company, in my opinion, and the landowner's opinion, is bullying them, threatening them, "Hey, you have to do this, you have to do this." No, they don't. No, they don't. And thankfully the person called, read it and say, "You don't have to do this." And say to the company, "Look, you can do these tactics all you want, but you don't have the right to do it. This person won't be signing anymore. And if you want to complain, you can complain to me, but it doesn't matter because I don't care because you don't have the right to do it. So you can either do one of two things: not do it, or pay money to the point that it justifies that landowner agreeing to do it. And maybe there's not enough money. Maybe it's just you're not going to do it. But that person wanted to find out their rights, said, "Hey, this company's threatening me, tell me I have to sign this, have to sign it," and sends me in. This was easy. I don't even know if it took maybe an hour. Said, "No, you don't have to do it. You don't have to do it, and here's why." So things like that, that's happening all the time. In my opinion, I see it all the time. So if I see a bunch of these examples, then I know it must be occurring all over, and nobody's, they're not calling me. They're just going ahead and signing. So again, put down the pen, pick up the phone, give us a call, 570-307-0702. And of course, keep listening to All Things Marcellus each and every week with me, Doug Clark, at this time on this station. So, I'm going to get into my big topic here. So I have this, which kind of change a little bit of the, not to make this too specific, but you'll get the idea. So let's say I have an older lady, very, very nice lady who's calls in to do a review and consultation. So calls in and also sends me a list of questions, things like that. And for this particular person, it is very, very important that, and it's a gas lease offer, and it's very, very important to this person that the company not be given any rights to touch the surface of the property, to use it in any fashion, including they don't want a well site, they don't want roadways, they don't want pipelines, they want nothing whatsoever to move the dirt on their property, on her property. She is open to signing a lease where gas is developed from another location through this horizontal drilling under her property, but she does not want to have a well site, pipelines, or anything on the property. Absolutely critical to this person. This person would not sign a lease if it provided any rights to operate on the property. So, person sends it in. Person says, "Hey," and it's kind of, sometimes I'll get these too, like, "Hey, everything looks great here. Just wanted to look at this real quick, make sure I'm not missing anything." Well, Thankfully, they did, she did, as you can imagine, or else I wouldn't be talking about this story. So, in this case, landowner sends it in. Now, remember, so let me go back a little bit and say, in a gas lease, as a general rule, every company has a form lease. Usually it's 2-3 pages. That's a form of the lease. That's the lease they hand to everybody. And then you as a landowner will try to add addendum terms, which are generally to your benefit in the additional document or addendum that you will attach to the lease. So the lease stays the same, but you negotiate the added addendum to be added to the lease. So sometimes, again, we say it all the time, companies are not dumb. They'll come out and they'll give you addendum terms when they're offering you the lease. My opinion, and doing this all the time, in part, they want you to think you got a good deal. They don't want you to question more. They don't want you to go an attorney who's going to tell you what you need to know. They just say, hey, look, and you got these addendum. Well, a lot of times, I've done many shows in this, it's not the quantity of the addendum or the number of the addendum you have. It's the quality, the power. What really do these addendum terms mean? I could give you 100 addendum terms that don't mean anything. That are just words. So you have to look, do these terms have bite to them, or are they just words that really have no meaning? So, again, just resetting, person gets a lease offer, and the company includes an addendum. And again, remember, in this case, the person really, really, really wants a no-surface lease, will not sign anything else. Says, hey, got this no-surface, sends in, do review, consultation, sends in the lease, sends in the information, review it. Again, this one isn't too hard for me. So we get the addendum and start reading through it. And I see that there's an addendum term for the location of the wells, saying that the company will use its, quote, best efforts to locate the well, to avoid timber value or crops. Listen, to me, that is a completely bogus provision, which means virtually nothing. Virtually nothing. So we take it means virtually nothing, and you need to understand that. Best efforts means virtually nothing in my book. So, but you might ask yourself, well, wait a second, Doug. Didn't you say this was a no-surface lease? The lady wanted to sign a no-surface lease. She told you she would only sign a no-surface lease. She told you the company gave you a no-surface lease. How are you, Doug, reading addendum terms that talk about the location of the well? Great question, guys. Great question. Glad you asked. Well, before I answer it, let me go on and say you could also ask the same question for timber. Here is a provision. It says that we go into property, we remove timber, we will pay you for the timber damage according to an appraisal. We're also going to, says here, that they're going to pay you for crops if they operate on the property. They also say that they're going to take care of soil erosion. So if they're building and if they install, let's see, shall construct or install well sites, access roads, pipeline right-of-ways in a manner which will reduce or minimize the risk of soil erosion. Well, access roads, well sites, and pipelines. I thought this was a no-surface lease. Oh, by the way, guys, I'm still just reading from the same addendum here. So, what's the next one? Surface damage restoration. How they're going to restore the surface. Next one, fences. How they're going to install fences around their operations on your property if you ask. Next, gate. Gate. How they're going to put a gate at the roadway. What are we talking about here? Isn't this a no-surface lease? What's the next one? Pipelines. Bury them to a minimum of 36 inches. Well, again, I thought this was a no-surface. The next provision. You can't make this up. Next provision. Cleanup. How they're going to clean up your property after they operate on it. So I just read nine addendum provisions that expressly and explicitly contemplates future surface operations on your property. And by the way, there's a paragraph at the beginning that says, in the event of any inconsistency between the addendum and the lease, the addendum controls. So that's the only thing. So I just gave you 9 terms in the addendum that contemplated expressly and explicitly surface operations on your property. So how in the world can this company even remotely say that this is a non-surface lease? Why does this person, client, think it's a non-surface lease? How does the land person tell them it's a non-surface lease? I mean, I know you work for the company, but geez, how are you saying that? Well, here we go. Here's a provision that says no surface use. So it goes on to state that the company is not permitted to use the surface of the premises to conduct work, construct roads, construct well pads, drill pads, or drill wells, install tanks, compression facilities, locate surface facilities, electric power, telephone, appurtenant facilities, or any other purpose. Wow. So I guess that's how, right, guys? Well, before I go further, let me ask this question. If you have an addendum that has 9 terms that all talk about how they can use your property, and you have a next term that talks about how they can't use the property, which one controls? Which one is the most powerful? If a court is going to look at this in the future, they're going to have to interpret what was the intent of the parties from just reading the document. And I'm not saying they decide this, but I'm saying if I was a company and I wanted to make this argument, I'd say, Your Honor, the intent was that you can tell there are 9 provisions that contemplate surface activity, 9, and only 1 that talks about no surface activity. So they are competing provisions. There's nothing in here that says one is more powerful than the other. So which one controls? Now, I don't think that you're going to end up in that fight. We would say on our side, well, what controls is this no surface language clearly controls because it says you can't touch anything. Well, on the other side, well, the company says we got 9 provisions that talk about how we're going to pay you for timber, how we're going to locate the wells at certain locations, how we're going to put gates and fences around these things. So again, which one controls? We stay out of that. My clients would never sign an agreement that had all these surface operations and then also 1 paragraph saying no surface. Also, another thing you can do, with just legalese stuff, you put in a phrase on the no surface if you were going to do it this way, which I wouldn't do, but you would put in a phrase saying, notwithstanding the other terms contained herein, meaning despite what these other provisions that appear to contemplate or do contemplate surface activity, despite them, this language saying we can't touch the property, that's what controls. But you don't even want to get there. You want to just you want to have a good no surface provision and get rid of all of these ones that are competing and conflicting with that. That's the way you do it right. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. But, guys, much, much more importantly, if it were just the 9 provisions that said we can operate on your property and 1 saying we can't operate on the property, you don't want to be there, but a court would probably, well, we don't know. You don't want to be there. But let's just say that we're comfortable that even though there's these conflicting provisions all over, we feel that the no surface operations provision will control. We feel that way. Well, I stopped reading, about halfway through that provision. So we have to keep reading the provision. So let me say this again. So in this case, the lady sends me this lease and this addendum, says it's a no surface use addendum. I won't sign any agreement if it allows for surface use. Won't do it. And company has told me and explained to me how this is a no surface agreement, so I'm inclined to do this, but I want you to look at it before I put my pen to paper. So let's get to the end of this no surface clause. So it has all these different things about, hey, we can't install tanks, well pads, roads, all these different items. Then at the end, there's one more sentence in this document, in this provision. So it is entitled, all bold letters, no surface use. That's the name of the provision. it's a fairly lengthy provision. Small letters, lengthy provision. Says how they can't do anything on the surface, and then comes the final sentence of this paragraph. And again, you cannot make this up. The final sentence says, notwithstanding the foregoing, meaning despite all the things that we just stated in this paragraph, how we can't touch the property, do dirt work, have appurtenances, any of these things, it says, notwithstanding that, company is permitted to enter the surface of the leasehold to conduct seismic activities and install pipelines. This lady, wonderful lady, says, I will not sign any agreement that allows them to touch any part of my property, roads, pipes, gas wells, drilling, anything. No problem, ma'am, no problem. We'll give you this lease. This is a no-surface lease. You don't have to worry about a no-surface lease. Well, again, I went through 9 provisions that contemplated surface activity. Then we get to the no-surface provision that says all of these different things we can't do. Then at the end is this sentence, that despite what was above, what we can't do on your surface, the company is permitted to enter your surface and to conduct seismic activity and to install pipelines. This, ladies and gentlemen, is not a no-surface use lease. Not at all. And I'll tell you what, there's one more provision that I'm going to talk about here in a second in the same lease. Coincidentally, the last provision, which is entitled pipelines. And I'm going to talk about that. We're going to loop all this together, and we'll talk about this other provision in the next segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call, 570-307-0702. 570-307-0702. Keep listening. Join me each and every week for All Things Marcellus. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, reviews, consultations of any offer or agreement, any oil and gas lease representation, breach or gas representation, breach of contract, unitization, royalty deduction issues. Again, unitization issues. Shut in, Tioga County guys. I'll try to talk about that more in the last segment. But again, just briefly, if you are shut in Tioga County for 8 years or more, have 100 acres or more, and are shut in and not received any royalties and been shut in for 8 years or more, give us a call. For this group of people, I'm doing free reviews and consultations to see if you have a claim to get out of your lease. And we've had some successes with some of these, and when you're successful, it's a big success. So in Tioga County, whether it's you, neighbors, whatever, get the word out. If you are shut in and you are held by a shut-in well for 8 years or more, I, Doug Clark, want to hear from you. Call the office, free, if in that category of people, 100 acres or more, free review consultation, and you can decide if you want to do anything or not. I'll give you my best information, my best advice. You decide what you want to do. 570-307-0702. Take advantage of it, completely free, no obligation. Again, 8 years or more, shut in, Tioga County. You're shut in, you're not getting royalties. I want to hear from you. Okay. So back to my other example. So if you're just joining us, I'll reset quickly. So I have a lady calls me, an older lady, wonderful, wonderful person, says, look, this family or property been in the family, cannot have anything touch the ground of this property. So I have a lease. I've explained this to the company. I have a lease, and I would like to do a review and consultation. I'm pretty sure I'm going to sign. It's a no surface lease, so I'm pretty pleased, and I just want to review, make sure I'm not missing anything. So the company says, yes, we'll give you a no-surface lease. She sends the lease to me. I review it to do the review and consultation. Again, this one's a relatively easy one, but a great example for the radio show to explain how people look. I don't know if it was malicious by the company, accidental, I don't know. But I know this, that had the lady not called and talked to me, it looked like she was going to sign this thinking she had a no-surface use lease. And I just went through in the last segment and said in this addendum, in the first part of the addendum, there were 9 paragraphs that contemplated surface operations on the property, such as, hey, when we operate, if we operate on the property, we'll pay you for timber, crops. Here's how we'll try to locate well sites. Here's how we'll put gates and fences around things. And then you get to one single paragraph that says no surface use. So you got 9 paragraphs that talk about surface use. And then you have one that says, no, you can't touch the surface. But then at the end of that paragraph, the last sentence says, despite all of these other words above about not being able to operate on your property, we as a company have the right to conduct seismic activities and pipeline installation. So this is not, it cannot be more clear. It is not a no surface lease offer. It is not. It is simply not. It expressly allows for seismic testing, but more importantly, pipeline installation. Pipeline installation. So something either happened. Either the company knew this and tried to dupe or trick this person, which I would like to hope isn't the case. But that's one possibility. There's no way around it. Or the company just didn't understand what they were doing themselves. And I guess that's another possibility too. But the person is told, hey, this is a no surface lease, and here you go, and we can't touch your property. It's just simply not true. It's simply not true. So we're back to, I started at the beginning. We in general, when people speak words and we hear them in our ears and process them in our brain, we have a tendency to believe that the words coming out of somebody's mouth are the truth. It's just how we live life. It'd be pretty hard living life if you thought every word out of everyone's mouth was a lie. So we think they're telling the truth. But we have to understand, in these matters of consequence to you, your family, and future generations, we must test and check on what we're being told to make sure that it is the truth. But then beyond that, we must make sure that we are doing the best we can for our situation. Somebody could still tell you the truth nonstop, but never tell you, hey, we'll actually pay you 5 times the money. So you need to check. You need to do this check to see, are you being told the truth, and what aren't you being told? That's another real big part of it. What aren't you being told? You're not being told about this pipeline in this example. But you're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. But let me give you one more part of this. So I say we got 9 paragraphs that talk about surface operations. Then we got to one paragraph that says you can't operate in a surface, but right at the end, it sneaks in, but we can install pipelines and do seismic testing. But then there's another addendum term. And, this is where it just smacks you in the face, where now you really have to say, was this an accident or are you trying to trick me? Because the last provision is called pipelines. And now remember, on the first page, there's also a pipeline provision, literally 2 provisions with the same name. So this one says pipelines. In the event a company desires to install, not like needs to, but desires to, wants to install a pipeline to install gas or oil on your property, you will enter into an agreement with the company. Will enter in, not may, will enter into agreement, and the company shall pay you, the landowner, $20 per foot as compensation. $20 for compensation for the pipeline and pipeline facilities. So does that mean you get stuff above ground? Well, it certainly means you can have pipelines. Oh, and by the way, it doesn't say that those pipelines are limited to transport your gas. It just says that the company wants to install pipelines if they desire to. And there's also assignable rights here. The company could assign rights to install pipeline to another company. So you come into this wonderful lady thinks, I got a no surface use agreement, when actually she has a no well site agreement. And she has an agreement that allows for pipelines, unlimited number, no location requirement, no input on location. Put them anywhere you want, as many as you want, as many times as you want, all across my property, and pay me $20 a foot. Boy, that's a lot different than what this lady thought the agreement was. A lot different. We got a little bit more left because, again, it just keeps getting worse. I'll be right back. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus, and call the office. Reviews, consultations, representation, oil and gas related matters, 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, give me a call, any oil and gas representation, 570-307-0702. Learn about representation, reviews, consultations, regardless of your location. Give us a call, 570-307-0702, and make sure that you keep tuning in to All Things Marcellus with me, Attorney Doug Clark. I've been doing the show since 2010, not stopping. We need to get this information out there. So, okay, we're talking about, again, very quickly, lady calls, says, hey, I want to do a review and consultation. Company has given me a no-surface lease that I'm ready to sign. But before I do, I've heard, put down the pen, pick up the phone, give you a call, do the review, consultation, make sure I'm not missing anything. I, as the landowner, she says, will not sign any gas lease that allows the company to conduct any operations on my property, to install pipelines, roadways, well sites, anything. So she says, I got this agreement, want you to look at it, no surface agreement, look at it, and as I talked about in the show, there are 10 individual addendum terms that all contemplate surface activity, and then one term that says we can't touch the surface, but at the end of that term, it says, aside from the fact that we are allowed to conduct seismic operations and install pipelines under this agreement, if we want to, just desire, not only if the gas or the pipelines are going to be transporting your gas, but no limitation, could be completely not your gas. Just all of a sudden now you have a pipeline across your property under the terms of your lease agreement, which you thought was a no surface agreement. So this was, just a really basic, and a lot of times there's even there's powerful hidden leverage in these reviews. But in this case, it was just, really easy to say to the client, unfortunately, here's the situation. Couple things. One, if you're going to sign an agreement that's a no surface agreement, you want to get rid of all of this language that says that they can operate on your property, especially in the addendum. You don't want conflicting addendum provisions unless you have language in there that says one addendum is more powerful than the other one. And this lease didn't have it. Then, on top of that, your language that says it is a, quote, no surface lease says that we can't do anything on the surface, and in the last sentence, with the legalese phrase, which many people do not know what it means, says, notwithstanding the foregoing, means forget everything else you just read. We're allowed to install pipelines under this agreement and conduct surface activity or seismic activity. Then it goes on to say that we can install not only just pipelines, we can install any pipeline we desire, no limitations of it transporting your gas, no limitations on the number, no input that you have on the location, no input on whether there could be multiple easements at different locations on your property, none of that. But you thought and you were told that you were signing a no surface lease, and it just simply isn't. So this person who did the review and consultation was obviously extremely, very disappointed to learn that they don't have what they thought they had and what they told they were given. But they were very pleased that they didn't sign the document, that they put the pen down, they picked up the phone, and they said, I got to just make sure everything's on the up and up here. So here it goes one step further. You're listening to All Things Marcellus with me, Attorney Doug Clark. So one step further, we're talking, and the person tells me the amount of money that they're being offered. And I said, boy, I'm not crazy about that number. I think that you should be offered more money. I think that's a low number in this case. Well, the companies, as they often do, do shows on this all the time, will say things like, that's all we'll ever pay. And another common type of thing is, well, Mr. Smith, who has this big farm, all we paid him was, and I'm going to pick a number. This is not the number in this case. $1,000 an acre. That's all we pay. Or that's what we paid Mr. Smith. And he has all of this property. And Mr. Smith, he's going to have the well on his property. And we can't pay anyone else more money than we paid Mr. Smith. It just wouldn't be fair. Oh, gosh, fair. So we're going to have to pay you the same as Mr. Smith. And I said to I say to my clients, as I say on the radio all the time, look, a company says they're not going to do something until the moment they do it. In other words, we're not going to pay any more than $1,000. We're never going to pay any more than $1,000. Ever, ever, ever. That's the most we're going to pay. We're paying too much now. Never, ever going to do it. Phone rings. Okay, we just increased the offers to $1,500. That's how it goes, guys. That's how it goes. Not, well, we may change, we may not, who knows. No one's going to sign if the company's all wishy-washy. They're going to say, this is it. You better hurry up and sign. It's going to go down. You're going to lose it. All of these different things. And then a lot of people get scared and sign. But then smarter people put down the pen and pick up the phone. But we all need to know, and the theme of this is credibility, okay? Credibility. Just because somebody says something doesn't mean it's true. We need to look in the minds and the motivation of the people who are saying the things. The used car salesman who's selling me a car may not tell me everything that I might like to know because this person wants to sell me the car. Not saying landmen are used car salesmen. Not saying that. Some people do. I'm not. I don't. I actually don't. They are trying to get your signature and trying to get it at the lowest price and the best terms for the company. Maybe, guys, maybe, news alert, maybe, they aren't telling you everything you need to know. Maybe they're not. And maybe you should be speaking with somebody whose job is to make sure that you know everything you need to know and you're not getting taken advantage of. Nobody wants to get taken advantage of. No one. And you don't want to get taken advantage of and simultaneously lose hundreds of thousands of dollars. That is something that's much more difficult to handle. So to close this thing out with this. So they say, this is all we're ever going to pay. So I say to the client, okay, here's the deal. I think the money's a little low. This isn't a no surface. Long story short, next, we'll fast forward, next scene. Person is paid more money, and the documents changed to do what the person wanted it to do. More money per acre that was told, oh, never pay more than that, and got what they want. So you could have received, this person could have just signed and believing what they were presented and believe what they were told, signed, and got less money and given extensive pipeline rights all across their property. Or did a review consultation, took 2 hours, found all the different problems, was able to then work to get more money per acre, despite the fact they were told that would never happen, and got a true no-surface lease. That, ladies and gentlemen, is just a textbook example. And some of them are much bigger, much more complex, but that's a textbook example. Do a review and consultation. Put the pen down and pick up the phone. Keep listening to All Things Marcellus each and every week. Remember, the landman works for the company, not you, the land owner. I, Doug Clark, have not, do not, and will not represent oil and gas companies. 570-307-0702. Have a great, great week, everyone.